Deep inside your computer is a tiny square of silicon, the brain of your machine. You rarely see it, but for decades, one name has dominated this space: Intel. Intel chips have powered everything from old desktops to today's sleek laptops. Their rise is a classic Silicon Valley tale: brilliant minds, relentless innovation, and clever marketing. Intel didn't just make chips, they set the standard. Intel Inside became a mark of quality and reliability. But when one company gets this powerful, it can squeeze out competition. That's where regulators, especially in Europe, start to pay attention. The tech world moves fast. What's cutting edge today is obsolete tomorrow. Yet Intel stayed on top for years, building a brand people trusted. Their dominance was so complete, competitors struggled to get a foothold. Enter AMD, the David to Intel's Goliath. AMD's fight to get its chips into computers became a high-stakes battle. This isn't just about two companies, it's about the choices you have as a consumer. Just like you expect options when buying a car, you should have options inside your computer. The struggle between Intel and AMD has played out in European courtrooms for nearly 2 decades. It's a story of power, competition, and the fight for fairness in tech. And it all starts with that tiny chip at the heart of your world. Antitrust sounds technical, but it's really about fairness, making sure no company can rig the market. Imagine a football match where one team has 20 players and the other just 5. Antitrust laws are the referee keeping the game fair. When companies compete, you get better products, lower prices, and more innovation. But if one company dominates, that incentive disappears. Why improve if customers have no choice? Regulators step in to protect competition, and you, the consumer. In Europe, the European Commission is the top watchdog, known for taking on tech giants like Microsoft, Google, and Apple. Their investigations are thorough, often lasting years, digging through evidence and company records. The goal: to see if a company abused its power to hurt rivals and limit your choices. When the Commission targets a company like Intel, it's a clash of titans, global corporations versus powerful regulators. The legal battles are long and complex, but the core question is simple: did the big guy play fair? In Intel's case, that question has taken years to answer. The outcome affects not just companies, but the entire tech ecosystem. Antitrust isn't just about law, it's about keeping the marketplace open for everyone. And that's why this story matters. The European Commission's case against Intel wasn't about chip quality. It was about secret deals. Intel allegedly paid major computer makers, HP, Acer, Lenovo, huge rebates, but only if they bought almost all their chips from Intel. Sometimes, Intel paid companies to delay or cancel computers using AMD chips. Imagine designing a new product, only to be paid not to sell it. These weren't small incentives, they were powerful enough to sway big decisions. For manufacturers, the choice was clear: stick with Intel and get millions in rebates, or risk it all with AMD. The Commission argued this stifled competition, not through better products, but through backroom deals. This wasn't a one-off. It was a sustained strategy from 2002 to 2006. The result? Computer makers faced a hidden tax for working with AMD. Consumers lost out on choice and potentially better prices. The real victim, regulators said, was you, the person buying the computer. That's the heart of the case. In 2009, after years of investigation, the European Commission hit Intel with a record $1.06 billion fine for abusing its market power. The fine was meant to punish Intel and warn others: this behavior won't be tolerated. The case centered on 2 things: conditional rebates for buying mostly Intel chips, and direct payments to halt AMD-based products. The Commission saw these as clear attempts to exclude AMD, with no benefit to consumers. Intel fought back, arguing their rebates were just normal discounts that helped lower prices. The legal battle began, winding through European courts for over a decade. The General Court upheld the fine in 2014, but Intel appealed again. In 2017, the top court sent the case back, demanding a closer look at the real impact of Intel's rebates. The billion-euro fine was now in limbo, and the fight was far from over. The saga became a test of how far regulators could go to police tech giants, and the story was just getting started. The Commission used a stark term: naked restrictions. In competition law, this means actions with no purpose but to harm a rival. No benefit to consumers, no efficiency, just exclusion. For example, paying a retailer not to stock a competitor's product. In Intel's case, the Commission said Intel paid HP, Acer, and Lenovo to delay or cancel computers with AMD chips. This wasn't about making a better chip. It was about making sure AMD's chip never got a chance. Regulators see naked restrictions as the most serious anti-competitive behavior. They directly attack competition, deny consumers choice, and stifle innovation. If big companies can simply pay to keep rivals out, the market stops rewarding the best ideas. That's why the Commission focused so heavily on these payments. Naked restrictions are a red line in competition law. The Intel case made this crystal clear. It's about protecting the very foundation of fair competition. After the top court's review, the General Court annulled the original billion-euro fine in 2022, saying the harm from Intel's rebates wasn't proven. Intel celebrated, but the story wasn't over. The Commission focused on the naked restrictions and recalculated the penalty. In 2023, they imposed a new, smaller fine, $376 million. This targeted only the most indefensible conduct, paying to block AMD's products. Intel argued the Commission couldn't just invent a new fine years later, but the Commission wanted to salvage a victory and send a message. The legal fight resumed, now over a smaller but still significant sum. Both sides dug in, knowing the outcome would set a precedent. The case became about more than money. It was about the rules of competition. The saga continued, with the next round set for the courtroom. Even after a partial win, neither side was backing down. The battle lines were redrawn, but the stakes remained high. Fast forward to December 2025, the General Court ruled again. The court agreed Intel abused its power with naked restrictions, so a fine was justified. But the $376 million figure was too high. The judges cut the fine to $237 million, citing two reasons. First, the number of computers affected was limited. The impact wasn't as widespread as the fine suggested. Second, there was a year-long gap between some of Intel's actions, so it wasn't one continuous offense. The court saw these as separate incidents, reducing the overall severity. The new fine better matched the actual harm done. For Intel, it was a partial win. For regulators, a confirmation that the conduct was illegal. The case showed how courts balance the gravity of the act with its real-world impact. The final figure, $237 million, a landmark, but not the billion-euro headline. The legal saga, however, still wasn't over. After 16 years, you'd think this saga would end, but not yet. Both Intel and the European Commission can still appeal to the EU's highest court. Appeals now are only about points of law, not new facts. Intel might argue the Commission shouldn't have reimposed a fine, or challenge the legal definition of naked restrictions. The Commission could argue the fine should be higher, or that the court misapplied the law. For Intel, it's about setting a precedent for future cases. For the Commission, it's about upholding tough standards for tech giants. The next move is up to the lawyers in Santa Clara and Brussels. The legal chess match continues, with the outcome shaping future tech regulation. The world is watching to see who blinks first. After 16 years of legal drama, why does this matter? It's about the rules that shape our digital world, ensuring tech giants play fair. When one company uses its power to shut out rivals, you lose choice and innovation. Regulators like the European Commission are the referees, keeping the market open. This case shows how hard it is to police fast-moving tech with slow-moving law. The Intel saga set new precedents for how to handle dominant tech firms. Europe sent a message. Fair play applies to everyone, no matter how big. The final fine may be smaller, but the principle stands. Abusing power to block rivals crosses a line. That lesson echoes far beyond computer chips. And it's a story that will shape the future of technology for us all.